Hello everyone, welcome to Courts Today by LiveLaw, your essential daily roundup for everything that is law. I'm Debojit Das and here are the top legal stories of the day. We'll begin with a crucial question for India's insolvency framework. The Supreme Court is set to deliberate on a major conflict between two statutes. Can a multi-state cooperative society submit a resolution plan under the Insolvency and Bankruptcy Code? This challenge arose after the National Company Law Appellate Tribunal or NCLAT ruled that a multi-state cooperative society was ineligible to be a resolution applicant for a corporate debtor. The specific legal hurdle involves reconciling the Multi-State Cooperative Societies Act of 2002, which governs such societies with the eligibility criteria set out under the Insolvency Bankruptcy Code. Given that these societies control vast capital and operate across states, the Supreme Court's final ruling will definitively clarify their status under the IBC, determining whether they can play a major role in acquiring and reviving distressed companies. The court has directed that the Central Registrar of Multi-State Cooperative Societies be made a party to the proceedings. Moving towards the south, as a new controversy over electoral accuracy has emerged in the Madras High Court, following the recent Bihar Special Intensive Revision exercise. The court heard a petition demanding immediate corrections to the Tamil Nadu voter lists. Former MLA B. Satyanarayanan argued that a systematic failure in maintaining the rolls, involving the mass deletion of genuine voters and the inclusion of deceased and duplicate entries, caused him to lose the 2021 T Nagar Assembly election by a razor-thin margin. He claimed that the ECI failed its legal and constitutional duty to conduct a demographic audit and verify reports highlighting the negligence of booth-level officers. Responding to the bench of Chief Justice Manindra Mohan Srivastav and Justice G. Arul Murugan, the Election Commission of India assured the court that special intensive revision of the electoral rolls for Tamil Nadu would commence within a week, signaling a move to address the serious grievances raised by the petitioner. The capital saw another important development taking place. Acknowledging that law must evolve to be truly equitable, the Delhi High Court is confronting a fundamental question. Can Section 498A of the Indian Penal Code, the law on matrimonial cruelty, be applied to disputes between same-sex partners? This issue was raised by Simmi Patwa, who is seeking to quash an FIR filed by her former partner, which includes charges of cruelty, that is Section 498A, criminal breach of trust, that is Section 406, and criminal intimidation, that is Section 506. Simmi Patwa, a biological female individual who suffers from gender dysphoria, claimed the relationship began as a symbolic marriage and led to severe emotional and psychological abuse. Patwa's plea highlights a critical legal void, noting that Domestic Violence Act of 2005 also does not apply to same-sex couples. The challenge centers on the strict gendered wording of Section 498A, which requires the complainant to be a wife and the accused a husband. With Justice Sanjeev Narola having issued notice, the court is now officially tasked with deliberating whether this gender-specific law must be interpreted narrowly or adapted to provide essential legal protection against cruelty in non-heterosexual relationships. Staying with the Delhi High Court as it clarified the limits of protective laws against commercial debt recovery. The Delhi High Court held that the SC/ST Prevention of Atrocities Act of 1989 cannot be invoked to prevent banks from enforcing their security interests. The dispute began with the Axis Bank initiated recovery proceedings under the SARFAESI Act against a defaulted loan of 16.68 crores, moving to take possession of the mortgaged property. Subsequently, a party claimed the bank's action amounted to an atrocity against a tribal person under the SC/ST Act, prompting the National Commission for Scheduled Tribes or NCST to issue summons to the bank's top executives. Justice Sachin Datta stayed the NCST's summons, holding that Sections 3 subsection 1F and G of the Atrocities Act are not attracted by the exercise of mortgage rights. The ruling prevents the misuse of SC/ST Act to halt legitimate commercial recoveries. Next, the Karnataka High Court recently refused to quash a 2020 case against Altaf Hussain, who allegedly circulated WhatsApp audio clips criticizing the state's handling of the COVID-19 pandemic. The petitioner was charged under Sections 153A, that is promoting enmity between groups, and Section 505 subsection 2 of IPC, that is statements creating or promoting enmity, for allegedly making scathing, provocative claims, including that a local MLA was misusing the COVID-19 situation for financial gain and that patients were being forcibly treated for a fee of Rs 40,000. Justice Sachin Shankar dismissed the plea, noting that given the magnitude of panic during the pandemic's first phase, the content of the audio clips, confirmed by an FSL report, constituted prima facie material to proceed to a full trial to determine if the claims were made recklessly or maliciously. Moving on to the Bombay High Court that delivered a scathing assessment of the Maharashtra government's 3 decades of failure to protect the vital Sanjay Gandhi National Park. A division bench of Chief Justice Sri Chandrasekhar and Justice Gautam Ankhad noted that since initial protection orders were passed in 1997, the state has taken no effective steps to comply with the judicial mandates, thus committing gross contempt of court. Despite orders to construct a boundary wall spanning 154 kilometers to prevent encroachment, the state has only managed 49 kilometers. In response to this institutional lethargy, the court has constituted a high-power committee chaired by former Allahabad High Court Chief Justice Dilip Bhosle to take over the responsibility of ensuring the boundary wall is completed, encroachments are removed, and a rehabilitation plan is implemented. Shifting our focus to the Kerala High Court as it directed the Bar Council of India to approve the state government's request for reservation for transgender students in law colleges. The court was hearing a writ petition seeking reservation under the transgender category for admissions to integrated 5-year LLB courses in government law colleges. The state government had requested the creation of 2 additional seats for transgender students across all law colleges in the state. As the BCI delayed the decision, citing the need for approval from its General Counsel with no meeting date set, Justice V.G. Arun intervened. The judge stated that the issue cannot wait endlessly and caused an interim directive compelling the BCI to grant approval within 10 days. And to wrap things up, in our second story from Kerala High Court, a major setback for actor Mohanlal. His ownership certificates issued by the state government for his possession of Ivory were quashed. The actor was originally booked in 2012 after the Income Tax Department recovered 2 pairs of ivory from his residence, an action registered under Section 50 of the Wildlife Protection Act of 1972. The certificates issued in 2016 were an attempt by the government to regularize the possession retrospectively. A division bench of Justice A.K. Jaishankaran Nambiar and Justice Jovin Sebastian declared these government orders and certificates illegal and unenforceable. The court, however, granted the state liberty to issue a fresh certificates in compliance with the statutory procedure under Section 44 of the Act. And that's a wrap for courts today. But we'll be back again as always to keep you updated with every major development that takes place in India's courts. And remember to access every story, judgment and order that was mentioned here and more, visit www.livelawmedia.pvt. I'm Debujit Das. Thank you for watching.